Section 83. Issue of debentures or debenture stock. 1. The company may raise a loan capital by the issue of a debenture or of a series of debentures or of debenture stock. 2. Debentures of the same series shall rank at the same rate in all respects, although they may be issued on different dates. 3. Instead of issuing debentures acknowledging separate loans to the company, the loans may be funded by the creation of debenture stock of a prescribed amount, parts of which, represented by debenture stock certificates, may be issued to separate holders. 4. Debenture stock shall be created by deed under the common seal of the company or certified by the signatures of 2 directors and the company secretary in the form of a deed poll or of an indenture in favor of trustees for debenture stockholders. 5. A debenture holder is not a member of the company and, despite a provision in the debenture or the constitution of the company, is not entitled to attend and vote at a general meeting of the company. Skip Section 84, 85 and 86. Section 87. Perpetual debentures. A condition contained in a debenture or in a trust deed for securing any debentures shall not be invalid by reason of the fact that the debentures are by that condition made irredeemable or redeemable only on the happening of a contingency, however remote, or on the expiration of a period however long. Section 88. Convertible debentures. Subject to the Central Securities Depository Act, 2007, Act 733, debentures may be issued on the terms that in lieu of redemption or repayment the debentures may, at the option of the holder or the company, be converted into shares in the company on the terms that are stated in the debentures. Section 89. Secured or unsecured debentures. 1. Debentures may either be secured by a charge over the property of the company or may be unsecured by a charge. 2. Debentures may be secured by a fixed charge on some property of the company or a floating charge over the whole or a specified part of the undertaking and assets of the company, or by both a fixed charge on a property and a floating charge. 3. A charge securing debentures becomes enforceable on the occurrence of the event specified in the debentures or the deed securing the debentures. 4. Where legal proceedings are brought by a debenture holder to enforce the security of a series of debentures of which that holder holds part, the debenture holder shall sue in a representative capacity personally and on behalf of the other debenture holders of that series, and Section 205 shall apply. 5. Where debentures are secured by a charge, Sections 110 to 121 relating to registration of particulars of charges, shall apply. Section 90. Meaning of floating charge. 1. Subject to subsection 2. A floating charge is an equitable charge over the whole or a specified part of the undertaking and assets of the company both present and future. 2. A floating charge does not preclude the company from dealing with the assets of the company until a. The security becomes enforceable and the holder of the security pursuant to a power in that behalf in the debenture or the deed securing same, appoints a receiver or manager or enters into possession of those assets. b. The court appoints a receiver or manager of the assets on the application of the holder, or c. The company goes into liquidation. 3. On the happening of an event specified in subsection 2, the charge crystallizes and becomes a fixed equitable charge on those of the assets of the company that are subject to the charge. 4. Where a receiver or manager is withdrawn with the consent of the chargee, or the chargee withdraws from possession, before the charge has been fully discharged, the charge ceases to be a fixed charge and reverts to a floating charge. 5. A fixed charge on a property has priority over a floating charge affecting that property unless the terms on which the floating charge was granted prohibited the company from granting a later charge having priority over the floating charge and the person in whose favor that later charge was granted had actual notice of that prohibition at the time when the charge was granted to that person. Skip sections 91, 92, 93, and 94. Section 95. Trustee for debenture holder. 1. Whether or not a debenture is secured by a charge over the property of the company, the debenture may be secured by a trust deed appointing trustee for a debenture holder. 2. A trustee shall safeguard the rights of the debenture holder and, on behalf of and for the benefit of the debenture holder, exercise the rights, powers, and discretion conferred on them by the trust deed. 3. Charges securing a debenture may be created in favor of the debenture holder by vesting the debenture in the trustee. 4. A provision contained in a trust deed or in a contract with a holder of a debenture secured by a trust deed is void insofar as it would have the effect of exempting a trustee of the holder from, or indemnifying the trustee against, liability for a breach of trust or failure to show the degree of care and diligence required of the trustee as trustee having regard to the powers, authorities, or discretion conferred on the trustee by the trust deed. 5. Subsection 4 does not invalidate a release otherwise validly given in respect of anything done or omitted to be done by a trustee on the agreement to that release, of a majority of not less than 3/4 in value of the debenture holders present in person, or where proxies are permitted, by proxy at a meeting summoned for the purpose. 6. Despite the provisions in the debenture or trust deed, the court may, on the application of a debenture holder or of the registrar, remove a trustee and appoint another trustee in the place of the removed trustee if satisfied that the first-mentioned trustee has an interest which conflict or may conflict with the interest of the debenture holder or that for a sufficient reason, it is desirable to remove that trustee. 7. Where an application is made under subsection 6 by a debenture holder, the court may order the applicant to give security for the payment of the cost of the trustee and may direct that the application shall be heard in chambers. 8. Where a trustee dies or retires, the registrar may appoint another trustee in the place of the trustee who has died or retired at any time before the appointment of another trustee in accordance with a provision to that effect in the trust deed. Section 96. Meetings of debenture holders. 1. The terms of the debentures or trust deed may provide for the convening of general meetings of the debenture holders and for the passing, at those meetings, of resolutions binding on the holders of the debentures of the same class. 2. Whether or not the debentures or trust deed contains the provisions referred to in subsection 1, the registrar may at any time direct a meeting of the debenture holders of a class to be held and conducted in the manner that the registrar thinks fit, to consider the matters which the registrar or the trustees shall bring before the meeting, and may give the ancillary or consequential direction that the registrar thinks fit. Section 97. Reissue of redeemed debentures. 1. Where a company redeems a debenture previously issued, the company may, subject to subsection 5, reissue that debenture. 2. The reissue may be made either by reissuing that debenture or by issuing another debenture in place of the redeemed debenture. 3. On reissue, the person entitled to the debenture has the same priority as if the debenture had never been redeemed. 4. The reissue of a redeemed debenture shall be treated as the issue of a new debenture for the purposes of stamp duty but not for any other purpose including a provision limiting the amount or number of debentures to be issued. 5. For the purposes of subsection 4, a person lending money on the security of a reissued debenture which appears to be duly stamped may give the debenture in evidence in any proceedings without payment of the stamp duty or a penalty unless that person had notice, or with due diligence might have discovered that the debenture was not duly stamped, but the company in either case is liable to pay the proper stamp duty and penalty. 6. This section does not entitle a company to reissue a redeemed debenture if the company has manifested the intention of the company that the debenture shall be cancelled or if reissued, is forbidden by a provision in the constitution of the company or in the debenture, trust deed or any other contract entered into by the company. 7. Where a company has deposited any of the debentures of the company to secure advances from time to time on current account or otherwise, the debentures shall not be deemed to have been redeemed by reason of the account of the company having ceased to be in debit while the debentures remain so deposited.